Funding for the Maddy Report is made possible by grants from the California Emerging Technology Fund, leaders in the quest for digital equity. The James Irvine Foundation, committed to a California where all low-income workers have the power to advance economically. Fresno State Associated Students, Inc., students serving students. BNSF Railway, moving our economy for 160 years. And The Wonderful Company. The Maddy Report is also made possible thanks to contributions from Harris Ranch Inn and Restaurant and E&J Gallo Winery. From the Maddy Institute, the Public Policy Institute for the Valley's 4 public universities, this is the Maddy Report with Executive Director of the Maddy Institute, Mark Keppler.
Welcome. Last year, Governor Gavin Newsom announced the Care Court program. That's the Community Assistance Recovery and Empowerment Act that's already been hailed as a fix to the state's broken behavioral health system and that's a road to recovery for those dealing with severe mental health issues. There are 7 counties that are scheduled to begin the launch of that program on October 1st. The state's other 51 counties are going to be launching their programs in October of 2024. Our guest is Thomas Curwen. He is an award-winning staff writer with the LA Times. He has written about some of the unknowns that California counties are going to be facing as they launch this mental health program. So welcome to the Maddy Report.
Hey, Mark. Thank you very much. Glad to be here.
So listen, can you explain to folks if they've heard about this Care Court proposal? What is it in basic terms?
Yeah, it's a good question. And I think it's really important that we try to shine a little bit of light on what the Care Court is. For this point of our conversation, I think I'd like to call it the CARE Act, because that's the name of the legislation that was signed by Newsom in September that puts into play what seems to be a pretty major reform of the behavioral health laws in the state. As you and your viewers may know, in 1967, legislators in Sacramento revamped the behavioral health system in California. And for the last 50 years, we've been living with the effects of the Lanterman-Prentice-Short Act. The Care Court represents the first major reform of that act, or I should say one of the major reforms of that act, and is designed to help prevent individuals from falling further into sort of the abyss of mental illness on the streets and in our communities. It implements a court system to try to help bring individuals into treatment, and will offer an opportunity for caregivers as well as families and roommates to bring people into the system.
Yeah, and part of this too is it's including court-ordered stabilization medications. It's talking about wellness and recovery, support, connection to social services and housing, lots of things. But here's a question that really comes up a lot, and that is this an infringement on individual liberties? I mean, how is self-determination supported by the Care Court program?
Yeah, it's a good question. The CARE Act. And it's a good question because, of course, the CARE Act was contested by Disability Rights California and also the ACLU. The courts decided that the CARE Act should go ahead after that lawsuit was considered. But with all these bills and all these acts, when it comes to mental health and mental illness legislation, behavioral health legislation, it's always a balancing line between respecting the autonomy of individuals and their civil rights, and also getting treatment to people who are desperately in need of that treatment. The CARE Act does a couple of things. First of all, it relies primarily on voluntary compliance to a treatment plan that's going to be presented to individuals who need that care. And also, if
it interrupt you for just a second, because that really is the question here. So it has to be voluntary, but they're dealing with generally untreated folks. They're dealing with schizophrenia on this range of schizophrenia, mental health problems. How can they make informed voluntary decisions?
Well, not all people with schizophrenia are completely without their own sort of sense of will and their sense of knowing what they need for themselves. Mm-hmm. So, I mean, there's a large range. I mean, this bill is going to target people with schizophrenia and schizoaffective disorder. And there's a large range between sort of competency and incompetency when it comes to that diagnosis. Again, I think the caregivers that are going to be going out into the street and meeting with these individuals are going to hope that they can get voluntary compliance. Persuasion, we get you off the street, we get you into housing perhaps, we get you treatment, and these individuals may have a memory of what that was like and may want to go ahead with that. If they don't, then they go into the court and that becomes a different situation altogether. And that's where another—
Well, let me ask this. No, I was going to ask, what are the key criteria for participating in the Care Court
Yeah.
Act
So
program?
it's really basic. Well, you have to be 18 or older, and you also have to have a clinical diagnosis in one form or another of schizophrenia or schizoaffective disorder. So it's really targeting people who are really very severely mentally ill and trying to bring them into treatment.
So what do you say would be the basic purpose of the Care Court Act? I mean, the way I read it, I'm looking at it's like an ounce of prevention. We're trying to get ahead of the problem before they go all the way to conservatorship. I mean, is that the way you see it?
Yeah, I mean, it's yet another tool that the legislators are being offering counties at this point to help with individuals who are mentally ill on the streets here and in their communities. It, like Laura's Law that was enacted in 2002, assisted outpatient treatment. Care Court is just another attempt to try to give counties and be able to help clinicians opportunities for bringing people in whom we see all the time that are in desperate need of help on our streets.
Yeah, up next, we're going to talk about that. How do the care courts differ from conservatorships and other state programs for the mentally ill?
Yeah.
Exactly how they work in conversation in a moment. This is the Maddy Report. Welcome back. I'm Mark Keppler with the Maddy Institute. We're talking with Thomas Curwen. He is with the LA Times we're talking about the state's new Care Act and what it'll mean for each county who has to implement these special courts. These courts are going to have the judges are going to have the authority to order treatment plans for individuals with untreated schizophrenia and related disorders. So I'm just wondering, Thomas, how is the Care Court different than the current approaches in California, namely the mental health for conservatorship, or that we talked about Laura's Law for outpatient treatment? How is this different?
Yeah, so the most significant difference between Care Act, and these other bills that you mentioned, other programs that you mentioned, is that the Care Act allows for family members and roommates to petition the court to get help for a loved one who is suffering from mental illness. Prior to the Care Act, the only people that could bring treatment to an individual would be qualified professionals, psychiatrists, law enforcement officers, crisis team members. But this is going to open up the door to family members. And I think it's pretty radical and pretty interesting difference and expansion of the plan above other programs.
Yeah, I think family members, you talk to them who have or dealing with this in their family are very frustrated sometimes that they can't get help to the family members that they're caring about. The system previous to this has been kind of problematic. So just to be clear about this, when people think that this Care Act is just another type of conservatorship, that's not a correct assessment. Is it?
Yeah, conservatorship is a different thing altogether. The Care Act is just a form of getting people and encouraging people into treatment. One of the great what's important to emphasize is that the Care Act is not mandatory treatment for individuals. It's a voluntary program. They hope to bring people into court. They hope that the presence of standing before a judge and in a courtroom with professionals around them, that will ultimately persuade people to adopt a treatment program. If they don't want to adopt a treatment program, there is nothing that the Care Act can do that will force them into treatment. However, if they refuse a treatment program, that may be evidence that they need conservatorship. And if they need conservatorship, then that kicks in the Landrum and Prentice Short Act, which will then bring these individuals into mandatory holds for 15 possibly 30 days, in which conservatorship can then be arranged.
Right. Okay. Well, can you why don't you walk us through, the typical Care Act program? How does it work?
Sure. So let's say a family member has a child who's on the street, and they want to bring care to that individual and start a treatment plan via the Care Act here. That individual will go to a particular courthouse in their county. They'll pay $433 as a petition filing fee. They'll fill out the form. Hopefully they'll get a little bit of help at the courthouse in filling out that form. That form will then go to the judge, who will then determine whether that individual meets criteria for the Care Act. If that person meets criteria for the Care Act, then the judge will mandate that an assessment team go out onto the street and find that individual and hopefully persuade them to adopt to a care treatment plan that they're going to put together for them. If that person declines, then that assessment team will be able to bring that individual into the courthouse, where the person will stand and be represented by a defense attorney, and will be able to stand before the judge and be able to hear what the plan is for their treatment. And this is a program that will last for about 12 months, possibly extended for 2 years. And hopefully it will be a complete wraparound service for these individuals and help them get into treatment and get well.
Yeah, one of the things that's kind of interesting when I was reading about this is that the Care Court plan is really developed by county behavioral health participants. They've got a care supporter who kind of part of a team. They got the defense attorney. I mean, there are a number of people there that provide protections for the individual when they're going through this program. And it is, I'm going to kind of stress, it is different than conservatorship. One of the things that they talk about conservatorship, the problem about, it's rarely timely. It's difficult to get granted. The other things I've read is that, it's sometimes it locks the participant up. This is a voluntary program that needs to really be stressed.
Yeah, it's really important. It's important when I talk to behavioral health directors throughout the state, they basically want to make sure that people understand what the CARE Act isn't. It isn't a program to cure homelessness in the state. It isn't a program that provides housing for individuals. It is a chance to help the most severely mentally ill people who need a treatment plan and need to get help and get off the street if possible.
Yeah, but I think that we'll have certainly the tangential effects, the benefits of this program are going to help people who are homeless that otherwise with treatment wouldn't have to be homeless. And they can maybe with proper medication and treatment can put their lives back in order and be productive members of society.
Absolutely. As we've all seen, there's such an intersection between mental illness and homelessness in the state, so that it's bound to have a residual effect on people who are living on the street.
Yeah. Well, up next, we're going to talk about how this Care Court is going to be rolled out statewide, how many people are expected to be treated in the program, and will the state provide enough money to cover the cost to the various counties? That conversation in a moment. This is the Maddy Report. Welcome back. I'm Mark Keppler with the Maddy Institute. We're talking with Thomas Curwen. He's with the LA Times about the Care Court Act. There are lots of specifics that need to be addressed, lots of issues that need to be considered. For example, how are the care courts going to be rolled out? Can you explain how they're rolling out this program?
Yeah, so the legislation required 7 counties to get the care courts enacted by October 1st of 2023. It was at that time when the bill was signed in September last year, then the other 51 counties would have another year to put it into place. Los Angeles County did, however, step forward and they're going to be rolling out their plan on December 1 of 2023. So that's going to leave the other 50 counties until October of next year. I think it's believed that those other counties are going to try to get their programs up and started before they hit that deadline, however.
Yeah. Okay, so what do you see when you're looking at this? What do you see as some of the challenges?
The challenges are multifold. I mean, I think many of these counties have to figure out what the funding is going to be for the CARE Act to extend itself beyond the first year. Legislature is paying for 1 year of this act, and I think counties are now wondering where the money is going to come from to keep this program going for years down the road. That money needs to go towards a whole raft of hiring that they need to do. There's a shortage of mental health and behavioral health clinicians in the state. I believe that San Diego County is going to need to hire the numbers like 18,000 healthcare workers over the next 10 years to meet what they anticipate this demand. And speaking of demand, I think the big question that's going to hit everybody is how many people are going to come into the CARE Act and qualify for the treatment and the programs. This is a big unknown for many of the counties, and I think they're sort of waiting to see and trying to anticipate the volume of individuals who are going to be hitting the system starting October.
Yeah, I was looking at that. I mean, some of the people, you just think, oh, just set up the system, it'll work. No, wait a second. You have to have clerks. You have to have psychiatrists. You have to have defense attorneys. You have to have behavioral health clinicians. You have to have judges. Insurance companies are going to have to add people. I mean, you start adding up all the people that were needed to make the system work. This is a really large undertaking.
It's a significant bureaucracy that they've started, and hopefully it's going to be effective. Yeah, it's interesting too.
It does.
I was going to say quickly, smaller counties are facing that problem perhaps greater than larger counties because they don't have quite the hiring pool that larger counties have. So I don't know how Fresno County is going to be coping with this.
Yeah, Fresno is a little large. Some of the smaller counties, though, like maybe Kings County or some of those others, it's going to be, or Tuolumne, it's a really smaller county. They're going to have some real challenges. But it's just very interesting. A lot of people, obviously, on the right, the Republicans complain. It's just another state mandate. They're not providing enough support. They're launching a program, and with no future funding. It's a common concern for a lot of state programs. Let me ask you that: why these particular counties? They picked these 7 counties to start. And it sounds like these counties are going to kind of be the guinea pig. They're going to kind of work through the system, the process, create a template perhaps for the other counties to follow. And also, it's kind of a little follow-up. Why did LA County jump ahead? They didn't have to. Why did they?
Yeah, these are good questions. I'm not sure if I'm completely clear on the answers, but I think the financial incentive speaks for itself. The first 7 counties were going to receive $26 million, or they were going to divide $26 million among them to help get this program going. So that's 7 counties giving $26 million for these programs. And then when the rest of the counties come on board, all 58 counties will then be dividing up $31 million. So the financial incentive to be one of the first is clear, and I think that's where these early counties understood that would be advantage to it. I think the state also might have been selective in the process because clearly the demographics of these 7 counties are different. You have very large ones like Orange County and San Diego, and then you have very small ones like Ptolemy and Stanislaus.
Yeah, I think one of the things, point you also made about there's no definitive count on the number of people that are going to be eligible for these programs. I think the state, what I've seen report is they're thinking 7,000 to 12,000. I've seen other reports that no, it's going to be much more than that. And we really don't know because we don't know how many families are out there that are going to try to avail themselves of this.
Yeah, that's exactly right. And I think that's what many of the counties are concerned about. When I talked to the behavioral health director in Orange County, she was telling me that they expect probably in the first year about 1,500 petitions to be processed in the first year. Of that number, she's hoping that they're going to get at least, of that number, they expect 500 to drop out for not meeting the criteria of the CARE Act. So of the 1,000 that are remaining, they're expecting to have 700 that will go to court and 300 that are going to be voluntary to the treatment program.
And by the way, the court dockets are already pretty impacted as it is. And they could create a new system here, but boy, you got to find the judges and the attorneys and all the rest of it. And I just want to, before we leave this segment, I do want to kind of stress one point. You're talking about the money given to the 7 counties versus the remaining 51. I did the quick math on this, and the quick math on that is basically those first 7 counties are getting in the range of $3-4 million a piece. Those next 51, $600,000 on average.
Yeah, exactly. The drop off is significant. Yeah, and I guess the state figures that the first 7 counties are going to develop the protocols and the programs that are going to make it much easier for the other counties.
That's smooth sailing because what could go wrong, right?
Right.
Anyway, up next, we're going to talk about the devil is in the details. What are some of the unanswered questions as we begin to roll out the CARE Court Act? That conversation in a moment. This is the Maddy Report. Welcome back. I'm Mark Keppler with the Maddy Institute. We're talking with Thomas Curwen. He is the award-winning staff writer of the LA Times. He has written about the governor's new CARE Act proposal. Some think this is going to be really a godsend for families who are unable to deal or assist loved ones who are dealing with mental health challenges. Others think, on the other hand, say, well, you know what? They're a little worried that maybe these folks are going to be frustrated by not being able to avail themselves of the services under the Act. There's a lot of practical questions going on here, and you raise a number of them in your article, and I encourage people to read what you've written. But you've said, one of the questions you've asked is who's going to serve the petition and transport the individual? Something very practical. Did you come up with an answer?
Well, this is a good example of just how granular this act can be. I mean, legislation in Sacramento can pass a big bill and set everybody into motion, but it's for the behavioral health directors of these counties to figure out how to put them into place. And that was one of the questions that they raised. Are the police departments, law enforcement, can be the people that serve the petitions, or behavioral health directors going to serve the petitions? There are a lot of arguments that can go back and forth between one and the other, and I think they're still trying to work those out.
And you can see potential conflicts of interest and all of that. Let me ask you this. There's also this dilemma posed by meeting this 14-day requirement when applied to the homeless. Can you explain what the problem is?
Yeah, so once a petition gets filed and the judge approves it, the counties then have 14 days to reach out and identify and interview and to assess that individual. 14 days can be pretty difficult if that person's living on the street. It means having to track them down. It means trying to figure out where they are and trying to have a conversation and build trust so that you can begin an initial assessment. For counties that don't meet that 14-day requirement, they're liable to be sanctioned, and that's going to be $1,000 a day.
Counties have to move fast. Quite a kicker. Yeah,
exactly.
And 14 think about that, 14 days to find someone and then get them to voluntarily go into treatment when homeless. I mean, it sounds like a pretty big challenge. Now, Dr. Mark Daily, who's the Secretary of California Health and Human Services, agency has called the county's efforts, quote, very promising, unquote.
Yeah.
You report, however, that county officials are telling you that the state may be moving too quickly. So who's right?
Yeah, well, unfortunately, the counties don't have much choice at this point. I mean, they can quibble about how quickly they're having to put this thing forward, but they've got to move to the clock that was set by legislators and by the state at this point in time. I think it's going to be interesting to see as the CARE Act gets rolled out, whether further adaptations and modifications to the legislation will be put into place once the more practical difficulties become more clear to the counties and to the judges and the courts as they try to implement this thing. I think there is room for amendments that's going to make it a little bit easier for the other 50 counties to adapt and to respond to the requirements of the law.
Yeah, and you think about, Darrell Steinberg, a former Senate pro tem, was pushed, mental health issues, the proposition, I can't remember the exact number. There are so many of them, but the proposition that supported mental health services. So this has kind of been a work in progress for a while dealing with this issue. And this is kind of the latest iteration. Hopefully you're correct that they will, do the evaluation, feedback loop, and then correct wherever, there are any problems.
Exactly.
Let me end with this. We only got about a minute left in a second, but I want to ask you this. Sure. What's your overall assessment of this program? Do you think it's going to work as intended, or are we going to have these unintended consequences?
That's the really big question. And that's what's so interesting about this legislation. I don't think we really know quite yet. Check with me in October and I'll let you know.
Yeah. Or then later that, because these things have a tendency to roll out over a period of time.
Yeah, exactly.
I want to thank our guest. I'm sorry, go ahead.
Oh, I was just going to add, I think what's interesting is we think about these laws. I think that probably in the first few years, it's going to be rolled out with the greatest amount of consideration and conscientious application and sensitivity. But you always have to wonder what it's going to be like 10 years, 30 years, 40, 50 years down the road. And when you have laws that infringe upon people's civil rights, you wonder whether this is going to open the door to something more grave or more promising. This is what time will tell.
Yeah, absolutely. The devil's in the details. I want to thank our guest, Thomas Curwen with the LA Times, for joining us. If you want to stay up in local and state politics, you can sign up for our daily newsletter, the Maddy Daily, by logging on to our website at maddyinstitute.com. This is Mark Keppler for the Maddy Institute. Thanks for joining us. The views expressed in the Maddy Report are those of the individuals participating in the program and do not necessarily reflect the views of the Maddy Institute. If you'd like to share your thoughts about today's episode of the Maddy Report, please visit our website at maddyinstitute.org.